in the matter in the Republic of Murima, in the High Court of Murima, petition number E5 of 2025, in the matter concerning the violation of human rights between the Murima Human Rights Commission as the applicant versus the Attorney General as the first respondent, Cabinet Secretary, Information, Communications and the Digital Economy as the second respondent, Cabinet Secretary, Treasury and National Planning as the third respondent, and finally, Inspector General of the National Police Service as the fourth. Teams, you may proceed.
First of all, good morning. Welcome.
With the permission of the President, probably before we start, if probably as the judges, we could introduce ourselves for the sake of the quorum.
Thank you. So presiding at this morning's session, my name is Justice George Odunga. And let my colleagues introduce themselves.
Good morning, presiding Professor Kameri Mbote.
Good morning, Gifnalis Okubo.
Good morning, I'm Virginia Nelder.
Good morning, I'm Dr. Conrad Bosiri.
Good morning, my name is Nabwire Obara and I wish you all the best.
Good morning, Ligunya Stephen. Pleasure to be here.
Just before you start, who is our timekeeper? Okay, so you'll alert us when time has run out.
The presiding judge, may it please this honorable court, my name is Ivan Kiriga, appearing as first counsel for the petitioner alongside my friend and colleague, Fiscal. With your kind permission, I will be taking the first 16 minutes to address the preliminary issue of jurisdiction and admissibility, then move to submit on substantive issues A.
Just a minute, you said you are Albert?
Ivan.
Ivan Kiringa.
Kiringa. And you say you are appearing for which party?
The petitioner.
Team code.
Yes, please proceed.
With your kind permission, I will be taking 16 minutes to address the preliminary issues of jurisdiction and admissibility, then move to submit on substantive issues A on the equal levy and C on the right to privacy. My co-counsel, Mr. Ahmed, will then address issues B and D in 17 minutes, reserving 2 minutes for rebuttal. Unless directed otherwise, I shall proceed with my substantive submission. My lords and ladies, how far can a government go before necessity becomes a pressure? Murima stands at a breaking point, where fundamental rights are no longer guaranteed, but rather bargained away in the name of policy and national security. The measures before this honorable court are more than their excesses. They represent dangerous precedent that, if left unchecked, will erode the constitution of its very nature. Hence, we invite this honorable court to stand as the last line of defense for each and every Murima and affirm that no justification, however noble, can ever excuse the unlawful limitation of fundamental rights. With all that in mind, allow me to proceed with my substantive submission. Turning to the preliminary issues of jurisdiction and admissibility, it is our submission that this court is vested with the requisite jurisdiction to hear and determine this matter. This court derives its jurisdiction from Article 165 as read together with Article 23 of the Constitution of Murima. These provisions empower this honorable court to hear and determine matters relating to the violation of human rights and grant the appropriate remedies. Hence, it is our submission that this court is vested with the requisite jurisdiction to hear and determine this matter. Moving to admissibility, it is our submission that this case meets the required threshold. We, however, recognize that an issue might be raised pertaining to the admissibility of issue B on the police brutality and enforced disappearances due to the availability of authoritative remedy in the Independent Policing Oversight Authority. It is, however, still our submission that due to the interconnectedness of the issues raised before this honorable court and the fact that they arise from a similar set of facts, that this matter is indeed admissible due to the preservation of judicial economy in Morimo.
Counsel, before you even go further, whether or not the issue of brutality should be addressed here, have you attempted to exhaust the local remedies? And if not, why not?
My Lord, the petitioners have not attempted to exhaust the local remedies. This is because, pertaining to issue B, with the availability of the IPOA, the Independent Policing Oversight Authority had 9 months to investigate this issue, yet pursuant to paragraph 42 of the fact pattern, they are yet taking any action.
Is there a set timeline in law as to what is reasonable time? Or why do you consider 9 months based on what precedent that 9 months is too long for them to have addressed such a complex issue?
My Lord, in our submission, that is no reasonable time for investigation. However, the matter in Morimo is one of an urgent nature, requiring investigations to have already been done. We are not asking for results, Your Excellency. We are asking for investigations to be conducted. And pursuant to paragraph 42 of the fact pattern, these investigations have not been conducted.
Counsel, the mandate of IPOA and the jurisdiction of the court, would you address us? Would the court be seized of matters which, under the law, IPOA is mandated to deal with?
It is our submission that in this particular issue, despite the fact that IPOA exists as an authoritative remedy, the petitioners can come before this honorable court because IPOA has not particularly done its mandate, which is to investigate this under their powers in Section 9 of the IPOA Act. And therefore, it is our submission that pursuant to paragraph 42 of the fact pattern, where we are informed that the IPOA is yet to take any action against any police officer, that this court is vested with the requisite jurisdiction to hear and determine. My Lord, it is our submission that the action that the IPOA has not taken is beginning the investigations as against the police officers who are liable for the police brutality and their enforcement cases.
Fair enough, please go ahead.
Turning back to my substantive submissions and moving to the first substantive issue before this honorable court on the equal levy, it is our submission that the equal levy does not strike a balance between the government's environmental objectives and the socio-economic rights of the people of Morimo. My lords and my ladies, we shall substantiate this further in 2 lanes. First, that the levy violates the right to reproductive this further in 2 lanes. First, that the levy violates the right to reproductive healthcare, and second, that the levy violates the right to access food and freedom from hunger. Moving to the first link, on the violation of the right to reproductive healthcare, it is our submission that the imposition of the equal levy violates the right to reproductive healthcare. My lords and ladies, Article 43 of the Constitution, as read together with Section 39 of the Basic Education Act, guarantee each and every school going girl the right to the highest attainable standard of reproductive health care. The African Commission in 2001, in the case of Serap in Nigeria, still harm members of marginalized communities breach the state's obligation to respect socio-economic rights. Similarly, General Committee Number 14 on the right to health emphasizes that states must refrain from retrogressive measures that make health-related goods inaccessible. Despite this, my lords and ladies, paragraph 17 of the fact pattern highlights that the levy will increase the cost of imported plastics by 150 shillings per kilogram, including sanitary products. Members of the bench, as it currently stands, the Ministry of Gender in the 2023 report highlights that about 65% of women and girls in Morimo are unable to afford these products. Now, my lords and ladies, imagine the implication of the church in this. This levy worsens an already dire situation. The same report from the Ministry of Gender highlights that school-going girls unable to afford these products are forced to miss 6 weeks of school annually. This reality denies them their right to education, perpetuates cycles of poverty, and deepens gender inequality. A fundamental right and ensure that no child is left behind to circumstances beyond their control.
Council, are you challenging the levy in and of itself or the level at which it's being applied?
My Lord, we are not challenging this test. It's because Ghana was in a similar position as Murima, where its debt and environmental pollution had reached a very big point. And in this matter, Ghana implemented their eco-levy in a phased manner that did not disadvantage members of vulnerable communities, but rather it was implemented in this phased manner and it was able to help Ghana not only overcome its debt crisis, but also its environmental situation. Turning back to my submissions, my Lord and Lady, and moving to the second limb of my argument on the violation of the right to access food. It is our submission that the imposition of the eco-levy violates the right of the Murimans to access food and freedom from hunger. My Lords and Ladies, Article 43 of the Constitution, as well as Article 11 of the International Covenant on Economic, Social and Cultural Rights, envision a hunger-free society. Despite this, however, paragraph 18 of the fact pattern depicts the harsh reality of the eco-levy as it will lead to an increase in the cost of essential goods. Picture the price of bread, which we rely on a daily basis, rising from 65 shillings to 74 shillings. Or even worse, the price of cooking oil, essential for each and every meal, rising from 300 shillings to 370 shillings. For families living on less than 150 shillings a day, these price hikes are more than mere inconveniences, they are devastating. They represent heartbreaking choices that parents have to make between feeding their children or placing a roof over their heads. My Lords and Ladies, the Supreme Court in 2021, in the case of Petitioner Welfare Society versus the Kenya Airports Authority, highlighted that state policies must promote the holistic realization of human rights. It is our submission that the respondents' actions fail the aforementioned test. By prioritizing environmental obligations, we are paying due regard to the socio-economic rights of the people of Burima. The respondents have indeed breached their duty to progressively realize these rights under Article 21 of the Constitution.
Council, is it for this court to draw a balance for the government on how to sequentially or gradually realize socio-economic rights versus environmental rights? Is that a purview of this court? And won't we be crossing our mandate into what is properly legislative and executive functions of government?
My Lord, in this instance, we are basically asking the court to assess whether the eco-levy is a threat to the constitutional rights, to socio-economic rights, and Article 15.
And I'm saying making it onerous does not mean it is a threat. Is it for us to tell the government, no, you must prioritize one set of rights over another? Is that a proper mandate of this court?
My Lord, it is not our submission that the government is supposed to prioritize socio-economic rights over the environmental obligations that they have. It is our submission that the government must take an approach that ensures that there is progressive realization of these socio-economic rights rather than limiting them within a progressive measure that is safe for them. My Lords and my Ladies, the petitioners recognize the importance of environmental sustainability. However, the law demands balance. By prioritizing environmental obligations without paying due regard to the socio-economic rights of the people of Burima, the respondents have failed in their duty to progressively realize these rights and therefore are in violation of the principles of equality and indivisibility of rights. We therefore urge this honorable court to declare the levy as an unconstitutional measure. Turning to the first substantive issue tabled before this honorable court on the right to privacy, it is our submission that the expansion of the powers of the Burima Revenue Authority violates the principles of the law of finance. Yes. You are. Yes. Turning back to my submission, it is our submission that the expansion of the powers of the Burima Revenue Authority fails the proportionality test to constitute a violation of the right to privacy as guaranteed under Article 31 Provision 3. The proportionality test, as established in the case of Nubian Rights Forum versus the Attorney General in 2021, requires this honorable court to consider whether the limitation in question pursues a legitimate purpose, is rationally connected to that purpose, is the least restrictive measure, and lastly, balances public interest with individual rights to privacy. My Lords and Ladies, It is our submission that the expansion of the powers of the Murima Revenue Authority are disproportionate and it is not the least restrictive measure. My lords and ladies, turn with me to paragraph 23 of the fact pattern. Paragraph 23 of the fact pattern highlights that the Murima Revenue Authority is to be granted expanded powers to review financial transactions. It is our submission that this blanket authority exposes individuals into arbitrary intrusion into their financial data, breaching the principles of privacy. My lords and ladies, the High Court in 2019, in the case of Kenya Human Rights Commission versus the Communications Authority of Kenya, struck out the device management system for failing to include proportionate safeguards. It is our submission that judicial oversight is such a proportionate safeguard that allows the Murima Revenue Authority to pursue its legitimate obligation, its legitimate aim of combating tax evasion while placing minimal and justifiable rights on the right to privacy of the Murima. My lords and ladies, it is clear that the expansion of the powers of the Murima Revenue Authority do not pass the principle of proportionality and therefore they constitute a violation of the right to privacy guaranteed under Article 31 of the Constitution.
Counsel, tax evasion, is it protected? Can you, the right to privacy, does it apply where there are clear cases of tax evasion and illegality?
No, my lord, the right to privacy does not apply. However, that is our bone of contention lies with the implementation of the expansion of the powers in the amendment section 51 of the Data Protection Act under paragraph 23 of the fact pattern. It is our submission that there existed lesser restrictive measures such as judicial oversight, which will allow the government to pursue its legitimate goals while placing minimal restrictions on the right to privacy of consumers.
How are you able to assess the proportionality when section 51 and the paragraph we've stated does not tell us exactly which are the exempted provisions? What is the test for proportionality?
The test for proportionality, as espoused in the case of European Rights Forum versus Attorney General, requires a limitation to pursue a legitimate purpose, to be rationally connected to that purpose. It should be the least restrictive measure, and lastly, it should balance between public interest and individual rights to privacy.
So within your few seconds left, was there a legitimate purpose?
Yes, my lord.
That's a legitimate purpose, isn't it?
Yes.
Was there a rationality as to why MRA would need to access the information?
Yes, my lord.
There is.
Yes.
Then you're talking about public interest. Were they acting in public or private interest? With the President's permission, Council could be allowed 1 minute. Were they being allowed, were they pursuing a public interest?
Yes, my lord.
And to that given extent, it seems the only bone of contention out of 4 is that it's not the least restrictive.
Yes, my lord.
And so if they strike 3 out of 4, don't you think that's enough reason for us to say that the balance is fair enough?
My lord, even one of the names, it must be struck down.
And this has been stated in what decision?
It has been stated in the case of European Rights Forum versus Attorney General, and further in the case of Kenya Human Rights Commission versus the Communications Authority of Kenya. In conclusion, my lords and ladies, the amendment section 51 of the Data Protection Act and consequently the expansion of the powers of the Human Revenue Authority, coupled with the equal levy, place unjustifiable limitations on the rights of the Murimas. We urge this Honorable Court to declare both measures unconstitutional and affirm the rule of law in the Murima. I now cede the floor to my co-counsel, Mr. Ratner, to address issues B and D.
Thank you, Counsel.
Judge, President, Your Excellencies, may it please this Honorable Court, my name is Sakal Ahmed, appearing as the second counsel on behalf of the petitioner in this matter. With your kind permission, I shall be taking the next 17 minutes to dispense with issue B on the Finance Act and issue D on the police brutality and extrajudicial killings, and thereafter proceed to give a praise before this Honorable Court. My lords and ladies, it is no longer business as usual when leaders are presumed to know what is best for the people without their input. Gone are the days of unilateral position and silencing dissent. We stand united in pursuit of a government of, by, and for the people as enshrined in the preamble of our Constitution. Given the gravity of the matters leveled before this honorable court and the distinguished expertise of the members of the bench, we respectfully seek to begin with issue D on the police brutality and extrajudicial killings. Turning to issue D, the petitioner asserts and maintains that the respondents violated Articles 24 and 26 of the Constitution of Burma, as well as Article 3 of the UDHR, Article 6 of the ICCPR, through the excessive use of force and the perpetration of enforced disappearances during the protests against the Finance Act 2024. These actions, we submit, were not only unconstitutional, but also aimed at silencing dissent, instilling fear, and eroding the very democratic fabric that Murima as a state prides itself in. We shall advance our arguments in two limbs. First, that the response is not applicable. They should use the minimum force necessary. The petitioner further places reliance on the African Commission's guidelines in policing the freedom of assembly, which directly and expressly notes that firearms are not appropriate tools for dispersing assemblies. Now, in stark contrast to this, allow me to guide you to paragraph 29 of the fact pattern, where the respondents unleashed on protesters, which is in direct violation of Provision 5B of the UN Basic Principles.
Council, just clarify for this honorable court. Paragraph 29 indicates that the protesters engaged in violent confrontation with the police, in which they began to throw stones at the police. When you're throwing stones, are you a protester or a criminal?
Your Excellency, in this instance, they're still protesters, but just because they are armed with stones, Your Excellencies, they still remain protesters. It is a submission that the respondents in this instance would have used less lethal force instead of using live ammunition and use of snipers, as seen in paragraph 33 of the fact pattern. It is a submission that pursuant to the United Nations guidelines on less lethal weapons, they could have used rubber bullets.
No, Counsel, I think I hear you with regard to what you're saying about the police, but please indulge us a bit more with regard to the protesters. Is the right to protest the right to take up arms, no matter how crude or violent?
Your Excellency, it is a submission and we do concede that the protesters were armed. However,
is the right to protest armed or only peacefully?
Pursuant to Article 37 of the Constitution of Burma, they should be peaceful and they should be armed.
It should be peaceful, isn't it?
Yes.
So when it is that they take up arms, no matter what the arms, are they still protesters enjoying the fundamental trappings of the Constitution?
No, Your Excellency.
They are not. So were the police dealing with protesters or were they dealing with criminals?
It is still a submission. They were dealing with protesters. Yes, they may not be under the ambit and the protection of the Constitution and Article 37 of the Constitution of Burma. However, the police should have used proportionate force in dispersing the crowds. They should have aimed to maim the protesters and not aimed to kill, like we have seen in the fact pattern. Allow me to guide you to paragraph 42.
Counsel, just a moment. On the same paragraph, we have, so in response, the police used tear gas canisters and water cannons. Those are less lethal weapons. And then they also used live bullets. Are you able to tell us whether, the escalation method was okay or there was something else that could have been done with respect to the fact that there were armed protesters?
Your Excellency, when we do note your concern, pursuant to the order given in paragraph 29 of the fact pattern, it states that the police used tear gas, water cannons, and live bullets. It does not show that they used it in the order that they have. It shows that they have used it indiscriminately, resulting to the death of 230 citizens as passed in paragraph 42 of the fact pattern, as well as the death of Mana Mandeli, who was a peaceful protester.
Before you take us, and so that we ensure that we are talking about the same thing, we are in paragraph 42. Are we talking about the same protest that was there in paragraph 29? Are those not two separate incidents?
Yes, Excellency.
They are. To the extent that you started at paragraph 29 during the first peaceful protest, In paragraph 28, we are told the purpose of the police when they went out was to offer security. Is that correct?
Yes.
And in that protest, how many protesters died?
35 protesters.
In paragraph 29, please look at it again.
1.
Are you sure? 35 protesters died?
Were injured.
Council, state that clearly.
35 protesters were injured.
Were injured. How many died?
Allow me to guide you to paragraph 40.
No, on 29,
29.
how many died, Council?
The facts are silent to be seen.
No, it doesn't. One of the protesters, Mwana Madledi, was shot and fatally wounded. Isn't that what it says, Council?
Yes, yes.
So despite using bullets and water cannons and all, the police killed but one. Do you still think it was disproportionate force restricting ourselves to what happened under paragraph 28 and 29? Wasn't that evidence of proportionality?
No, Your Excellency, it is a submission that there is no proportionate use of force. While you do concede that the protesters were armed with stones, the respondents have used water gas, tear gas, water cannons, and live bullets. One policeman was injured, yet 35 protesters were injured. Your Excellency, there is no proportionality in this, and as seen in paragraph 42 of the fact pattern, even when the second protest had happened, 230 citizens had died. Showing in the aftermath, 230 citizens had died. As such, Excellency, it is a submission that the use of force by the respondents was excessive and therefore unlawful. Turning to the second limb on the enforced disappearances, Article 2 of the International Convention for the
Go ahead.
Article 2 of the International Convention for the Protection of All Persons from Enforced Disappearance defines enforced disappearance as deprivation of liberty by state agents and the victim's whereabouts are concealed. Article 3 of the same statute further goes to stipulate that the state is required to take measures to investigate and to bring to account the perpetrators of enforced disappearances. Now, in stark contrast to this, allow me to guide you to paragraph 40 and 41 of the fact pattern, where again, a university student was abducted in a unmarked and identified vehicle. The respondents may purport that there is no direct evidence linking them to this event. However, we ask this court to ignore the test of circumstantial evidence as was laid out in the case of Kimani v. Republic in 2020, where it stated that when a case rests entirely on circumstantial evidence, 3 conditions must be met. First, that the circumstances from which an inference of guilt is sought must be cogently established, that the circumstances must unerringly point towards the guilt of the accused, that the circumstances should form a complete chain such that no other conclusion except that the accused is guilty. Now, applying that to the facts at hand, the protesters disappeared under suspicious circumstances. The pattern disproportionately targeted vocal activists. Given the timing of the disappearances, the consistent use of unmarked and unidentified vehicles, and the lack of the state to investigate, it follows then that they should bear the responsibility for the enforced disappearances. And we ask this court to grant us an order of inquest, mandating the state to make an inquiry into the disappearances of our citizens.
Counsel, again, are you aware and familiar with the Tehran case? Have you ever heard or are you aware of the facts of the Tehran case?
Yes.
It basically states that our state is not responsible for acts of rebellious bodies of men within its territory. You have just told us that the circumstances must be cogently established. What in paragraph 40 or 41 makes you believe that this was the police?
Your Excellency, allow me to guide you to paragraph 40, where some of the citizens who had disappeared were found in police cells, suggesting that the police had conducted and that the ones who were using the unmarked and unidentified vehicles.
Is there anywhere in paragraph 40 that it suggests that the ones who were found in police cells had been taken by marked, unidentified vehicles?
While that may not be the case, Your Excellency, and while we may not have any evidence to corroborate the circumstantial evidence, it is the nature of enforced disappearances that it does not come with signed confession. Your Excellency, these are crimes of concealment, where the absence of evidence is part of the strategy. And we ask the Honorable Court to stand and hold the state to grant us an inquest and hold out the procedure of enforced disappearances.
Has the state addressed the issue of the enforced disappearances? Has it addressed it at all?
Yes.
What have they said?
They have said that you have to establish the custody pursuant to paragraph 63 of the Law Society of Kenya as Attorney General, where the text of custody is such that if it can be shown the victim was at some point in the custody of the police, then the state, the court can interpret, the court can scrutinize the legality of that detention.
And even in that regard, the ones who are in their custody or in the police cells, how do we know the one mentioned in paragraph 40 was ever in their custody, other than the time and the vocal nature of the person?
When we may not have direct evidence linking them to the state, in the alternative that the court is not persuaded by our argument, we submit that pursuant to Article 21 of the Constitution of Murima, the state still bears an obligation to protect their citizens, and as such, by allowing non-state actors to perpetrate such enforced disappearances, then they are still to be held liable for the same. In conclusion, as we conclude this issue, we pray before this Honorable Court to grant us an order of inquest mandating the state to conduct inquiries into the enforced disappearances of our state, of our citizens, and to find that the use of force was excessive. Turning to issue B on the Finance Act, the conundrum before this Honorable Court is whether the government may justify fiscal policies that were enacted in a manner repugnant to constitutional safeguards. It is our humble submission that the respondents disregarded their constitutional duty to accountability, transparency, and public participation, thereby violating the spirit and letter of Article 201 of the Constitution. We shall advance our arguments in two limbs. First, that the equal levy fails to equitably share the burdens and benefits, and second, that the state failed to facilitate meaningful public participation. Turning to the first limb on the inequitable sharing of burdens and benefits, by dint of Article 201B of the Constitution of Murima, fiscal measures must distribute burdens fairly and equitably. The equal levy introduced by the Finance Act 2024 violates this principle. Honorable Judges, in the Okiya vs. Cabinet Secretary of Ministry of Health, the court held that fiscal measures must not deepen socioeconomic inequalities. Yet, the equal levy does precisely this. Allow me to guide you to paragraph 18 and 19 of the fact pattern, where the cost of essential goods have increased. Bread now costs 9 shillings more, while cooking oil costs almost 17 shillings more. For families living on less than 150 shillings a day, these price hikes are devastating. Paragraph 19 further shows that the increased cost of menstrual products has forced many girls out of school, perpetuating cycles of inequality and poverty. Now, the respondents have increased the cost of essential goods, yet they are yet to account for some of the funds. Allow me to guide you to paragraph 15 of the fact pattern, where the Auditor General's report shows that there are some funds which are yet to be accounted for. As such, it is a solution that they fail to equitably share the burdens and benefits contrary to Article 201B of the Constitution. Turning to the last limb on the facilitation of public participation, the respondents failed to properly sensitize the public. In an exercise of proper sensitization of the public, it is not enough to simply call for input. The government should educate the public on the nature, the importance, and the impact of the proposed legislation to ensure that public participation is informed and not blind. Allow me to guide you to paragraph 26 of the fact pattern, where the respondents may claim that they invited for public participation through a newspaper notice in the Murima Daily. However, it is a solution that a simple newspaper notice cannot suffice for meaningful sensitization. Given the fact that the Finance Act was highly technical and far-reaching economic consequences, the state failed to provide structured and meaningful engagement for the public.
Council, do you want this court to injunct Parliament from carrying out its core business of legislation, including the finance bill?
Certainly not, Your Excellency. In this instance, this is a Finance Act. Allow me to guide you to page 20 of the fact pattern, where the issues have been listed to be, whether it has been listed to read, whether the government violated the principles of public finance and Article 201 of the Constitution of Kenya through the Finance Act 2024. Now, pursuant to Order 11, Rule 3 of the Rules of Procedure, the parties to this, the petitioner, the respondent, and the court together sat down and decided and determined the issue to be one of Finance Act. And as such, It is a submission, it is a Finance Act, and the court can decide on the legality and constitutionality of the same.
Counsel, according to you then, what is the threshold for public participation?
The threshold for public participation is one of reasonable opportunity, and that is as stated in the Robert Kakuru versus County Governor of Jammu, where reasonableness is to be determined on a case-by-case basis, and factors such as the nature, the impact, and the importance of the proposed legislation should be considered. Given the fact that this is a Finance Act and it affects literally every single person's life, the citizens of Morima should have been given a reasonable opportunity to have a say in the legislation.
Counsel, still sticking to the same point as much as your time is running out. You're saying the newspaper was not enough. And my question first is, says whom that is not enough, an opportunity? Two, you're arguing that the document is so technical that a newspaper is not enough. How do you marry that to paragraph 27 of the fact sheet, where not only are your people so enlightened, they even came up with a simplified version on their very own? And lastly, do you admit that not only did they participate, their views were considered, and even how they were considered was tabulated?
Noting that my time is up, I would request the indulgence of the court to grant me action to proper consideration and response.
When your time does not run, when you are answering questions after the time given to you, so that's what proceed.
Thank you, Excellency.
So my questions, to make them simple for you, who says the newspaper is not enough as a standard? Two, you talk about the technicality of the document, but in the fact sheet, a simplified bill version was created by your very citizens, meaning they understood. And lastly, their views were considered under paragraph 26 and a draft report given. Wasn't that sufficient and more than sufficient public participation?
Your Excellency, in responding to your first question, it is not our submission that the newspapers was not enough. Public participation should be determined on a contextual basis. In this instance, as pursuant to paragraph 4 of the fact pattern, 65% of the Morimans rely on digital platforms. Additionally, at paragraph 12 of the fact pattern, the head of state himself talked about the transformative power of digitalization. As such, it is a submission that the state should have used both newspapers and digital platforms because they have digitalized over 1,700 essential services. Yet, when it came to public participation, they conveniently looked away. It is a submission that this is not public inclusion, rather it is public exclusion by design. In responding to the second query on the consideration of the views by the public, it is a submission that pursuant to paragraph 57 of the fact pattern, the Parliament did in fact consider the views. However, they conveniently chose the views to select. Paragraph 27 shows that there was overwhelming opposition rejecting the bill. Yet, at paragraph 28 of the fact pattern, it says, while we do note that Parliament does maintain discretion in enacting the laws, this discretion is not absolute. It is subject to the principle of transparency and accountability. As such, it is a submission that the respondents did conduct public participation, but they conducted it as a mere formality, as they did not take into account the views of the public. In conclusion, as we leave the fate of the vulnerable Morimans in your hands, Your Excellencies, we pray for the following. A declaration that this court has jurisdiction under Article 165 and 23 of the Constitution to hear and to determine this matter, that this matter is admissible, having met all procedural and substantive thresholds, that the equal levy fails to strike a justifiable balance between the government's environmental objectives and the socio-economic rights of the citizens of Morimans, that the state violated the principles of public finance and Article 201 of the Constitution, that the amendment to Section 51 of the Data Protection Act is unconstitutional, that the state used excessive force and then perpetrated enforced disappearances. Judge President, Your Excellencies, thank you. The petitioner rests and we cede the floor back to the court pending our 2 minutes of rebuttal.
Counsel, before you sit down, what stage do you determine whether the public views have been considered and taken into account, but for one reason or the other, Parliament is not persuaded by those particular views?
Your Excellency, in answering your question, allow me to guide you to paragraph 27 of the fact pattern, where the respondents received 203 stakeholder memoranda. Yet they focus on one clause. They deleted one clause. On the one hand, they will suggest that the removal of the proposed tax increase on online money transfers was adequate consideration of the views, but they conveniently ignored the overwhelming opposition, gathering up to 124,000 petitions. Your Excellency, they have decided to ignore what was in the public outcry, which is why we're before this honorable court, which led to the protests that occurred. As such, it is a submission that the public participation they conducted was a mere cosmetic and it was not the procedural safeguard that it should have been.
Is it your submission that after Parliament considers the views, go back to the public and tell the public that they have now considered your views, you have accepted this one, and this one, but you have rejected this one, and this one?
Yes, Your Excellency. They should provide justification as to why they reject or accept certain views, and this is as provided for at paragraph 67, Governor of Kiambu.
But Council, isn't that exactly what they did? There was a committee struck that reviewed all of the memoranda and the submissions, drafted a report, highlighted the views collected, and how such views had been considered. Are you finding fault with that process? Why?
Your Excellency, our point of contention is not that the state did not facilitate meaningful public participation, but rather after they conducted public participation, the issue with is how they conducted. Sorry, Your Excellency, I don't need to begin again. The question is not that public participation was not done. Rather, after it was done and the people are talking about what they were not comfortable with, the state decided to conveniently ignore them, which led to the public outcry, which led to the protest. For 1 second, Your Excellencies, let's entertain this thought. What if the equal levy was removed away or the views of the public were considered? Would the protest have happened? Would 230 of our citizens have died?
But are they required to make everybody happy and implement all of the views, or isn't it just that they're supposed to consider, give reasons, and then make the difficult decision about what to implement and what to not?
Your Excellency, it is a submission that they are supposed to consider the views and provide justifications as to why they reject. However, it comes to a certain point when we revert back to the sovereignty of the people. The citizens themselves are not happy with this. Why is the state forcing this upon them? It is to that end that we submit that the enactment of the Finance Act 2024 is unconstitutional, and once again ask this court to declare so. Thank you once again.
Thank you,
Please, this court, counsel on record for the respondents, I am Oswin Trevor, appearing as first counsel. I appear alongside co-counsel Winjoy Gitonga. If that suffices, I may proceed.
Team Court.
Much obliged.
For the purpose of the record, once again, I am Oswin Trevor. I will handle issues 1 and 2 in 18 minutes. Co-counsel Winjoy Gitonga will handle issues 3 and 4 in 17 minutes.
Get your first name properly.
Oswin. O-S-W-I-N. W-I-N.
Okay.
Much obliged. My lords and my ladies, we can't breathe. There's a knee on the government's neck, hindering all its obligations, its constitutional mandate, and everything it seeks to do in protection of its citizens. The applicants have submitted or have portrayed a picture of a government that has neglected its obligation to protect its citizens as well as protect its constitutional obligation. We, however, before this court, seek to prove that this government is taking steps to protect these very citizens whom gave us the mandate to appear or to represent them as their government. Has been adapted in this specific nation, we submit that there is a 3-tier test in regards to availability of remedies before one seeks audience before the court. That one, the available remedy must be available. One, the IPOA Act, Section 7A of the IPOA Act can either, on its own motion, suo moto, receive or conduct investigations regarding police brutality. In the alternative, IPOA can receive complaints from the applicants. We submit that per the fact pattern, the applicants have not approached IPOA to conduct investigations on what they allege is actions of police brutality. On the second qualification, in regards to efficiency, we submit that
Before you go to efficiency, and so that we just move with your 3-part properly, you have just said that they have not moved IPOA. Is IPOA akin to a court where it is that only what is brought before it is investigated? Are they deaf, dumb, and blind until activated?
Much obliged. We submit that IPOA, on its own motion, granted by statutory authority, can move itself to conduct investigations.
So it can?
It can.
All right. And do you also submit or admit that it's been 9 months and nothing substantive has been done?
We do concede that 9 months after the fact, nothing has been done.
But you still think the remedy is available?
Much obliged. We submit that in representing the respondents, IPOA is not part of this case. We do not want to plead IPOA's case in regards to its inefficiency to address the matter before it.
So you admit they have been inefficient?
In regards to instituting its own motion, yes.
They have been inefficient. Now,
yes.
If they've been inefficient, you are standing here as a representative of the state. Is that correct?
Yes.
And therefore the buck stops at the state. Is that not a state institution?
Much obliged. IPOA is an independent authority away from the government's interference.
Established under your own laws and regulations, right?
Yes.
Citizens have disappeared and there's been brutality, yet the relevant institution has not moved. You still think the case is not admissible before us in light of indolence of 9 months?
Much obliged. We admit that this case can be heard before this court.
So it's admissible?
It's admissible. However, we submit that issue 4 be held in abeyance in regards or relying on the case of Benson Ambuti versus Kibos Distillers, so that this court can, one, issue a structural interdict requiring IPOA to submit an authoritative report with the requisite forensic and technical expertise that is have before this court, so as to hold the specific people who killed protesters, specific people who conducted these heinous violations to book. As in Article 20 of the Constitution of Burima, every person has an obligation to respect the Bill of Rights, not the government as a whole.
Counsel, you're saying that we issue an interdict against IPOA. Is IPOA a party to these proceedings? Can we issue orders to a party that, or a body that is not participated in the proceedings? And secondly, under Article 165 of the Constitution, please address this court on the unlimited original jurisdiction of this court and what you're suggesting with regard to the third parade order.
And just linked with that, as you answer it, also address to yourself whether the IPOA Act then removes the jurisdiction of this court.
Much obliged. We submit that in addressing my Lord's question first, IPOA Act does not remove the jurisdiction of this court. We submit that where the IPOA is not a party to this case, as was held in the Me Too Welfare Society case versus the Kenya Airports Authority in the Supreme Court, the courts cannot pull in a party. However, we submit that through the powers of the courts can ask, as per the case of Onunga versus the Attorney General in 24, can ask IPOA to provide a report linking specific actions of the police in regards to their human rights violation. So this court has the power to ask IPOA to provide before it as its report to help it adjudicate on issue number 4.
Counsel, Does the government then dispute the findings of the human rights watchdogs? Does the government dispute that there were 230 deaths and 39 succumbed to bludgeoning from police batons? Is that in dispute, those facts?
The government does not dispute the numbers of the people who are killed, and we sympathize with the ones who are killed and injured. However, we cannot establish a link between the actions of the police in regards to those killings. That's why we ask this court to allow IPOA, with the requisite technical and forensic expertise, to give us a link, if any, between the government or the police officers and the actions or the killings that are seen in Article 42.
So the 91 that suffered from inhaling tear gas, you say we're not sure how that happened?
Much obliged. In regard to that specific issue, we submit that every citizen who is under the Constitution in Article 20 is given a mandate to protect the Bill of Rights. We submit that these specific actions, in as much as they can be attributed to the police, we ask this court to allow IPOA to give us the specific people so that we can introduce criminal liability to the specific police officers who went overboard with regards to their mandate.
That's fine, but that's not what they're asking us to do in this case. This is not about criminal liability, right? The question before this court is the state's obligation under Article 21 to protect the citizens. And so are you telling me that we need a report from IPOA first just to say that there were deaths and that there were police who were responsible for us to know that the state did not fulfill its obligations?
Much obliged. This court can move on its own motion to address the matters before it. However, the adversarial nature of the court system in Kenya does not allow this court to go into the specific facts or to do an investigation. Since the matter brought before it, it's not an inquiry. It's an adversarial, or the applicants have invoked the adversarial system of this court. So we ask that this government hold this matter in abeyance, not excluding the court's jurisdiction, but to hold it in abeyance so that it can benefit from the report from the Independent Policing and Oversight Authority, as was held in the case of Onunga versus Attorney General 2024.
Counsel, before we proceed, are you aware of any other state agencies that investigate matters around extrajudicial executions and torture other than IPOA?
Yeah, per Section 87 of the National Police Service Act, we have the Internal Affairs Unit.
Any other? No worries. Have they received any complaints on these cases? Specifically based on paragraph 29?
Per the fact pattern, no. We haven't been told any specific organs have received these complaints.
All right, so you're simply banking on IPOA to do the job?
We are benefiting from the expertise.
That clarity is useful for this court. Thank you.
Much obliged. Proceeding to substantive matters, asking this court to rule itself in regards to the admissibility of issue 4. I submit on the first issue regarding the striking of a justifiable balance between the government's environmental obligations and the socio-economic rights of the citizens. We submit that the socio-economic rights of the citizens, as well as the government obligations, are linear in their application. Hence, which Article 43 doesn't come above Article 69, or Article 69 above Article 43 in the Constitution of Murima. However, we submit that Article 43 rights are guaranteed or are governed by Article 21(2), which is the principle of progressive realization. In the case of Mitubel Welfare Society versus the Kenya Airports Authority in the High Court, the courts gave us a test in regards to progressive realization. When the government is approached, or when the court is approached by any persons in regard to the achievement of progressive realization, this government the court has to limit its test to one, whether the government has protected or has done everything possible to protect the social economic rights, on whether the government has done all it could to protect these rights, and on whether there has been maximum use of resources. On the first question, on whether the government has done everything to protect, one, the reproductive health of the citizens of Murima, we submit that per Article 21(2) of the Constitution, this government has a duty to enact legislative, policy, and any other measures to protect this right. The government has enacted the Basic Education Amendment Act, Section 39K, giving school-going girls the requisite materials or menstrual health products that they require to further their right to education. So in regards to protecting this right, we have taken legislative measures that aim to provide the highest attainable standards of health. In regards to the second question, has the government done all it could? And I attach this to the third question on the maximum use of government resources. We submit that this is a government that is facing economic shocks, as seen in paragraph 6 of the fact pattern, where this government has suffered from Wanana pandemic, this government has suffered from droughts and famines that have dwindled or have made the economy dwindle. Honorable members of this court, we submit that the government has the intention to recognize, to protect, to fulfill and to respect all aspects of Article 43.
Council,
what we lack...
Do you still think your government is doing the best it can in light of the various shows of hubris and excessiveness by your own leaders, such as those captured in paragraph 24 of the fact sheet? And similarly, the resources that are being bled out within the national government, CDF and all, are you really utilizing the resources as you should?
Much obliged. We concede that there has been excess portraying of opulence with the government officials as well as the Office of the Auditor General flagging this report. However, in reliance to Article 226 of the Constitution of Murima, in Section 5, we submit that the Constitution gives a personal liability to anyone who misuses public finances. So we ask this court to allow the Ethics and Anti-Corruption Commission, the Office of the Inspector General, as well as all other requisite bodies under the AKEKA Act, that's the Anti-Corruption and Ethics Act, to allow them to conduct the investigation and hold the specific people personally liable per the Constitution.
Counsel, is it really right to ask this court, in light of the grievances that are being brought, twice now you are telling us don't touch it, let IPOA deal. Now you are saying don't touch it, let ethics and anti-corruption deal. So the court should sit back as and until this government decides when it will do what it should do, or its respective institutions. Is there not a constitutional paradigm where it is that you as a government are obligated to actually show that the budgeted sums are being used effectively?
Much obliged. There is an obligation by to the government per the Constitution to ensure we are using these finances well. To add checks and balances to that, there is an establishment of the Office of the Auditor General, as well as a statutory mandate to all these other bodies to investigate on the same matters. That's why we ask this court to allow the independent units or bodies established under law to conduct the investigations to guide this court on ruling on the constitutionality or not of government actions. In proceeding, I submit that on the second question on whether the government has done all it could or used its maximum resources, we submit that this government does not have resources. In regards to the Limburg principles that guide the application of the ICESR that this government is party to, available resources are not only the resources within the country, but you can also rely on international aid. In paragraph 5, I direct this quote to the paragraph 5 of the fact pattern, where the government has taken loans to improve the health and education sector. In as much as we've done all this, we've done everything sought to collect revenue, and we still have a 346 billion deficit in regards to our budget. This government does not have the requisite financial wherewithal to address or to give all these people in Murima the socio-economic rights. What are we doing about it? Honorable members of this court, this government seeks to introduce new measures to curb, among other things, environmental degradation that is the biggest threat to social economic rights in our country. We have seen instances where the government, where the country has suffered from heavy rains and flash floods. In paragraph 21, 150,000 who have been limiting their affordable housing. Schools, hospitals have been swept away by floods. Environmental issues are the biggest problem we are facing in regards to the attainment of social economic rights. We submit that the introduction of the eco-levy, that is a question before this court, is one that was aimed to curb the misuse of plastic or the 1 ton, 22,000 tons of waste. Does this government...
If you're saying the people are struggling due to the various natural calamities and challenges, but you're saying the levy is the answer, and which, as we're being told in the fact sheet, increases the cost of living and even access to food and basic human right and dignity aspects. How do you marry those two? The answer is to take more?
Much obliged. In regard to your question, I seek to introduce before this court Professor Aharon's J. Barak, components of a proportionality test. We submit that before this court, we are seeking to introduce that there is a proper purpose in regards to the achievement of the environmental obligations. And the wording of the Constitution in Article 69 is shall. This is an obligation by the government to, one, among other things, in G, to eliminate all threats to the environment. Plastics are a threat to the environment. So there is a proper purpose that is sought by this government in regards to the introduction of the eco-levy to eliminate all aspects of plastic waste that are a threat to the environment. In regards to the others on whether there is a rational connection, we submit that the plastics that are being imported into the country, as well as the waste that is being seen in the country, they are directly connected. We impose a levy in regards to the plastics that are coming into the country. We eliminate the waste management problem that we have. There's a necessity seen in paragraph 21 where people are dying, others are losing their homes because of environmental issues. And on the fourth one, was this the least restrictive? We have tried to introduce the extended producer responsibility. We have initiated urban waste management mechanisms in paragraph 3. All these are not working. We are still facing environmental issues. What we want before this court, or what we ask this court to allow us to do.
I'll take you back again, and you've taken me on a very long rigmarole. My question was simple. I have people that you're admitting are struggling, and I have people who you are admitting do not have access to food. They've had a lot of challenges with the environment. Yes, but your eco-levy has the effect of making it harder for them to find food and upkeep. Where is the justification in that? The plastics aside, tell me about the ethnocentric aspect, the people's lives.
Much obliged. In addressing your question, the government has to strike a balance in regards to its intergenerational equity that is provided for in Article 201C. We have an obligation to the people, that is the anthropological sense, but we also have an obligation to the ecosystem, that is the ecological or ecocentric test. We submit before this court that this government, in the introduction of the eco-levy, aims to balance both. You eliminate the environmental challenges that we are facing. We protect the socio-economic rights of the people of Murima.
So protect them from the plastics, but kill them with the food.
We submit that the actions of the eco-levy will not kill the people with the food. We are eliminating imported plastics. Plastics in the country will continue being used, gradually being phased out. So this is specifically on imported items. I ask the presiding judge in the court for 1 minute to converse on issue 2.
Okay. As you take your 1 minute, you also deal with my issue. One of the relief that you've proposed is the interdict, isn't it?
Pardon?
Interdict is the relief that you have proposed as regards IPOA.
Yes.
You know the limitations of that particular relief. You know it has limitations.
Yes.
What is its efficacy with respect to IPOA, where IPOA has not told us what steps, if any, it took and what limitations it had?
Much obliged. On that specific issue, this court has the jurisdiction to question all actions or all actions done under constitutional authority. We submit that this court can ask IPOA in regards to its constitutional obligation to investigate on its own motion or to receive complaints on whether it has actually conducted. IPOA, when brought before this court, will be required to answer before you on why, where, and how they aim or why they haven't done the requisite investigations. Much obliged. In regard to the second issue, we submit that this court rely on the case of Ministry of National Treasury and Planning versus Okia Omtata, a Supreme Court case in 2024 that laid the principles of public participation as well as how public participation aimed to be done. We concede that this government has not enacted legislation that guide on the specific aspects of legislation, but we submit there is a process ongoing before the Office of the Auditor General that will be submitted to the legislature in regard to addressing the specific issues raised by the applicants in regard to how many people need to be reached, how the government will ensure that accounting officers in each and every ministry conduct their duty on public participation, and to further improve the constitutional obligation of the government per Article 201 on accountability, openness, and public participation. I cede floor to co-counsel.
Thank you.
Presiding Judge, distinguished members of the bench, and may it please this honorable court, my name is Winjoy Gitonga, second counsel appearing for the respondents in this matter. Over the next 17 minutes, I shall respond to the allegations brought before by the applicant regarding the third and the fourth issue. With this court's permission, I will proceed. Much obliged. The respondents contend that the government did not violate the Constitution and data protection regulations, and there was no violation on the right to privacy. Additionally, the police used reasonable and proportionate amount of force. Additionally, the allegations against extrajudicial killings and abductions remain unproven, and we ask this court to dismiss them accordingly. Moving on to the third issue. The government adhered to the Constitution and data protection regulations while limiting the right to privacy by amending Section 51 of the Data Protection Act. It is our submission, or rather our position as the respondent, that the applicant in this matter has not contested to the legitimacy of the limitation. However, they have contested on the issue of proportionality, as espoused in the case of Jacqueline Okuta versus the AG, and also the case that the first counsel for the applicant has submitted before this court, the case of Nubian Rights Commission. It is our submission that the proportionality test in this matter was fulfilled, and the applicant has raised an important issue on the less restrictive means. They have stated that according to Section 51 of the Data Protection Act, the judiciary has the duty, or rather the power, to be exempted from the data protection regulations, and this is actually a less restrictive matter. However, I invite this court to turn with me to paragraph 6 of the fact pattern and paragraph 7 of the fact pattern. From paragraph 6, we see that the economy of Murima has dwindled due to the Wanana pandemic of 2020. Additionally, out of this pandemic, a lot of Murimans lost their jobs, therefore reducing the tax bracket and tax revenue collection in Murima. Additionally, under paragraph 7, we see that Murima has had shocks to its economy due to extreme drought and extreme floods facing the Muriman Republic. Additionally, under paragraph 23, the last sentence, it states that the Muriman debt is increasing to a rate of 71% of the gross domestic product of Murima. This shows that the existing mechanisms have proved to be insufficient. While the applicant has raised the issue of judicial authority under Section 51 of the Data Protection Act, it is evidenced under paragraph 23 that this measure has proved insufficient. While we do understand that amending Section 51 of the Data Protection Act might raise the issues of oversight mechanisms, it is a submission that there already exist oversight mechanisms in Murima to check the power of Muriman Revenue Authority while accessing financial records.
Which oversight authorities are you saying exist?
Much obliged. One of the oversight mechanisms that exists is the Tax Procedures Act. Under Section 6 of the Tax Procedure Act, it provides for the confidentiality clause. Additionally, under Section 104 of the same Act, it provides for sanctions, that anyone who contravenes the sections of the Tax Procedure Act is liable to certain sanctions when they have contravened the sanction.
Given that the exemptions given to MRA are not specified, are they not right in being concerned that even probably what you're saying has been exempted as far as MRA are concerned?
Much obliged. Well, we do understand and we do concede that under paragraph 23, they have not specifically stated on which exemptions MRA will be exempted from. It is our submission that the MRA, the amendment of Section 51 of the DPA is not absolute, and MRA is still complied to follow the data protection regulations, to follow the Tax Procedures Act.
Counsel, one of the arguments made by the applicants before us is that under the Nubian rights case, when you're having this kind of limitation of rights, the test is a conjunctive one, not a disjunctive one. And if I understood counsel well, they were saying that doesn't matter if you step 3 right and step 1 wrong, you're out. Do you concede to that level of scrutiny and that of the test of limitation?
Much obliged. We do concede that the test is indeed a conjunctive test, and it is a submission that the respondent raised the issue specifically regarding the less restrictive measures. But it is a submission that according to paragraph 23, the debt is growing to a point of 71%.
There is no question about the debt growing. The question is, was this the least restrictive measure? The debt is growing, so we allow you to snoop into every single person's data to the level that you're proposing under the MRA, or for the MRA to do? There was no other option?
Much obliged. It is our position that there was no other option that the Murima Revenue Authority could have used in this circumstance.
Okay, please give me an instance, practice, whether regionally or internationally, where this kind of measure has been upheld or judicially upheld.
Much obliged. While counsel is not aware of any jurisdiction that has used this limitation, it is a submission that it needs to be handled in a case-by-case basis. That in this case, we see that already under paragraph 23, the debt is increasing, meaning that if there existed less restrictive means, such as the one offered by the applicant, it has proved to be insufficient. Because if it was sufficient, then we would see at least a balance, or rather the debt decreasing. However, in this case, it's increasing. And therefore, the Murima Revenue Authority came up with this tax regulation in order to sufficiently address the debt crisis in Murima.
Counsel, is it your observation that the fact that the debt is increasing and there is economic problems is a result of not accessing information from taxpayers? Is that your submission?
Much obliged. Our position is that under paragraph 23, the exemption, or rather the amendment of section 51, was to address tax evasion and ensure tax compliance. And this runs proportionately with when tax compliance is actually met, then the debt will be decreased. However, in this case, the debt is increasing to a point of 71% of the gross domestic product. It is also our position that according to paragraph 12, the government has come up with the open government plan, which has set guidelines on the kind of the scope of data to be collected, ensuring that there is no intrusion on the right to privacy. This is a measure that the government has enacted under paragraph 12 of the fact pattern through the open government plan. Therefore, the government is ensuring that while MRA is accessing these financial records, there are set guidelines and scope of the kind of data to be collected and the extent of data to be collected, therefore minimally intruding on the right to privacy.
Counsel, you seem to be saying debt is increasing because of tax evasion. Is that true? Is it the only reason that debt will increase because of tax evasion? Or there are other reasons that will also be leading to tax increase in the debt? So why focus on these tax measures?
Much obliged. it is not our position that this is the only way a debt can increase. However, ensuring tax compliance will raise the revenue of Murima and therefore will actually address the debt crisis in Murima. And this is a measure that Murima Revenue Authority has come up with, that we do a tax regulation measure in order to improve tax compliance, in order to assist in helping in the debt crisis in Murima. Seeing that I have 8 minutes, and if it suffices, I shall now move on to the fourth issue of this case. The respondent contends that the police used reasonable and proportionate force against violent protesters. Under paragraph 29, and it is the main contention brought by the second applicant, the second counsel for the applicant. The second counsel for the applicant has brought the issue that the police used disproportionate force against the protesters. However, I invite this court to paragraph 29 of the fact pattern.
Counsel?
Yes.
Can I actually invite us to paragraph 35 of the fact pattern, and that's how I would like you to address the use of force.
Much obliged. Paragraph 35.
Yes.
Much obliged. The issue under paragraph 35 is about the protest that took place in Parliament. It is our submission that Parliament is a protected area according
But it says an entire CBD. It's not restricted to Parliament. Yes?
Much obliged. I invite this court in answering your question to paragraph 32 of the fact pattern, which states that a few individuals expressed their intention to engage in a violent confrontation with their representatives to pursue accountability. Additionally, through an ex post under the same paragraph, it says, and I shall read in verbatim, "Kesho ni kesho, when I meet my region's women rep tomorrow, I will beat some sense into her." The same protest that Honorable Lady Justice has guided me to under paragraph 35 happened on the same day. It is a submission that the police had reasonable belief that this protest would turn violent, and therefore they used reasonable force to quell unlawful and violent protest. While we do understand that some people were injured and some people were killed, we ask this court to give us adequate time to investigate the matter and to find the individual police officers who conducted these heinous crimes.
Counsel, again, it's not just some people that were injured. Your police targeted members of the Fourth Estate. They beat journalists who I want to believe were properly designated and equipped as journalists from covering the protests. Where is the proportionality in that? Because someone said they will meet their MCA or their women rep, we now beat journalists, and we see proportionality in that?
Much obliged. We do concede under paragraph 35 that there was the police used an excessive force. However, it is our submission that this court should grant the respondents enough adequate time to investigate the matter and to find the individual police officers who are actually culpable or responsible for these heinous crimes.
Individual culpability aside, the applicants are seeking to hold the state. You're telling us, so admitting that the police used excessive force, have not the applicants met the threshold for this court, therefore, to hold the state culpable by your own admission?
Much obliged. We do concede under paragraph 35 that it is a bad fact for the respondents. However, it is a submission that without finding the individual police officers who unlawfully violated their duties in the course of work, it would be impossible for this court to find that the Inspector General, who is my client, individually criminally responsible for these crimes. As evidenced, yes. Much obliged.
Counsel, do you understand anything to do with command responsibility?
Yes.
So how does that apply to the Inspector General when it comes to a case where you're not able to, find, as you say, the specific officers?
Much obliged. This court, in the case of Kenya Human Rights Commission versus Joseph Komen Chebere, held or rather addressed the issue of the issue of command responsibility. It is an international law doctrine, and the court did not offer a conclusive idea or rather a conclusive statement.
The court did.
Yes? The
court did offer a conclusive understanding.
Much obliged. Yes. However, the court still held that in that matter, the Inspector General, who was Joseph Kome, that he could actually be taken through a criminal procedure, and that the heinous crimes committed by the police, how they would now bring back the issue of command responsibility.
And yes. Counsel, once it has been shown that the police were acting within their ostensible and actual authority on the day, isn't that sufficient for us to hold the state and the police responsible collectively, regardless of the individual officers? That's a you issue, not a court issue with regard to the prayers sought.
I'll kindly rephrase your question.
Once we are saying that there's command responsibility, when we are saying that the officers were acting as officers on the day of the events, isn't that enough for this court to find in favor of the appellants or the applicants before us with regard to the police responsibility, irrespective of individual responsibility?
Much obliged. It is our position that in any case that this court finds that indeed the police used excessive force, it is our position that according to could you kindly rephrase your question?
Let me move to a different question tied to it. Where is the proportionality on paragraph 42?
Much obliged. We do concede that paragraph 42 states that 100 people had succumbed from bullet wounds, 91 had succumbed from tear gas. However, it is a submission that we do acknowledge that this is a bad fact for the respondent. However, in this matter, we ask this court to give us adequate time to investigate and find the individual police officers who are...
My question was simple. Where is there proportionality?
Much obliged.
As per the facts in paragraph 42.
Much obliged. Indeed, there is no proportionality. However, without the adequate investigation, we cannot connect the individual police officers to the specific crimes. Which police officer actually fired the bullet? Which police officer excessively conducted these violations? And therefore, without this conclusive investigative report, it would be a burden for now the respondents as the Inspector General to hold him individually criminally responsible while the actions were conducted by individual police officers. And in addressing the issue of abductions, the applicant in this matter brought up the issue that several people were found in police cells and relied on circumstantial evidence to prove that these police officers were actually connected to the alleged abductions.
How much time do we have? So how much time do you require?
1 minute.
Wind up.
Yes. Much obliged. In regards to our prayers, the respondents pray that this court grants the respondent leeway to enact policies to mitigate environmental degradation while balancing the right, or rather to pursuant to Article 25C of the Constitution. Secondly, the court to find that the government has furthered its objectives in terms of Article 201 of the Constitution in positive steps in accountability and openness. Thirdly, the court to find the respondents adhered to the principles of public participation as espoused in the case of Ministry of Treasury versus Okia Omtata. A declaration that the right to privacy was limited lawfully, legitimately, proportionately, as there exist oversight mechanisms to check on the powers of MRA. Lastly, a declaration that the police used proportionate force in self-defense while awaiting for a conclusive investigative report from the Independent Policing Oversight Authority. The respondents rest their case.
Thank you, Counsel. Before you rest your case, we have listened to your submission, and unless maybe I missed it. Does your government have in place any legal instruments guiding demonstrations and protests?
Much obliged. There is the Public Order Act, which provides for the kind of use of force, or rather what the police should use or do in terms of a protest or a demonstration.
That's the only legal instrument?
There is also the National Police Service Act and the National Police Standing Orders.
Any specific legal instruments dealing with the demonstrations and protests?
None that I know of. However, there is the Public Order Act, the National Police Service Act, and the National Police Standing Orders.
Is there any requirement anywhere for that kind of legislation to be enacted?
Pardon?
Is there any requirement anywhere for that kind of legislation to be enacted?
Yes.
Has it been done?
Not yet.
So on what basis can we say that your government should not be held liable when you yourself admit that there were some excesses?
Much obliged. It is our position as the respondents that we do concede that under paragraph 42, there are 230 deaths. That is a bad fact for us. However, we submit before this court to allow the Independent Policing Oversight Authority adequate time to investigate the matter and to find the individual police officers who actually, or the allegations, whether they did use unlawful use of force or whether they used proportionate force.
Thank you.
Much obliged.
Anything in rebuttal?
Judge President, Your Excellencies, it is my privilege and honor to appear before you once again. My name is Fiscal and I am here to address our 2 points of rebuttal on the right to privacy and the enforced disappearance. But before I begin, taking note that the Counsel for the Respondent failed to respond to our submissions on Article 201B and D, we take it to mean that they are in concurrence with the petitioner for the same, and we ask the court to rule in our favor. Turning to our first rebuttal on the right to privacy, Counsel for the Respondents have argued that the amendment to Section 51 of the Data Protection Act is proportionate, as it does not grant indiscriminate access to data, but only allows for limited data retrieval for tax compliance. Much like the legal argument, this illusion cannot withstand the weight of truth. We submit that this is not proportionate, as there exists a lesser restrictive means. They could have used judicial oversight or independent regulatory mechanisms. The court in the Nubian Rights Forum versus Attorney General struck down part of NIMS for the sole reason that it lacked judicial oversight, reinforcing that even necessary measures must have checks to protect fundamental rights. A ruling in favor of the respondent would erode data privacy protection, normalizing unchecked government surveillance over citizens' data. Turning to the last rebuttal on enforced disappearance, my lords and ladies, respondents have argued and asked this court to dismiss the allegations of enforced disappearance as there is no direct evidence linking them to the state. However, this argument falls at the weight of its own impossibility. We submit that the absence of direct evidence does not absolve the state from its responsibility. Rather, it underscores the need for heightened scrutiny. In the Velasquez-Rodriguez versus Honduras, the Inter-American Court of Human Rights made it clear that when disappearances occur in a context where the state has a pattern, then the burden shifts to the government to disprove its involvement. A ruling in favor of the respondents would legitimize state impunity, limiting human rights violation. The respondents, Judge President, Your Excellencies, the petitioner rests. Thank you once again.
Thank you, Counsel. I believe you have come to the end of this particular matter. And on behalf of the bench, I want to thank you very much for your able presentation. We will consider your submissions and we'll give you our decision on notice. Is that clear?
Court, it's been very interesting listening to both sides arguing their issues very vehemently, and I think it is clear that the parties did give quite some time to considering the issues. On the issue of environment and socio-economic rights, I think there is one issue that would have been good to dig a little bit into. There is a link between the two, because if you don't have a good environment, some of the socio-economic rights are going to be affected. And also the source of pollution. Does it matter that the source of pollution is internal and not imported? I mean, that you didn't bring it in through trade from outside. The pollution is still pollution. If there is plastic that is in a jurisdiction, it is still problematic in terms of affecting people's right to a healthy environment.
Thank you. Maybe just a brief comment, not necessarily arising from this particular session. One thing is that as counsellor you must always be aware of is that advocacy is about persuading the court. Most likely by the time the judges come to your matter, they've already gone through the document that you placed before the court, and now it's just upon you to persuade the court, particularly when you're appearing before the hearings are physical rather than virtual. So that the way you actually present your case becomes very, very important. Because if you lose the court right from the beginning, then you can be sure that half of your case is gone. So the only thing that remains is the paperwork. So it is very important that when you are presenting your case, you ensure that you do not lose the court. You ensure that the court understands what you are talking about. And you must ensure that you keep the court engaged. One of the instances where you lose the court is when, for example, you take too much time reading your notes. And the court is there waiting and listening to you when you are just going through your notes. So it's usually best that you summarize your case, make it very brief, identify your strongest points so that you don't run out of time, because sometimes you run out of time when you have not dealt with your most important issues in the case. So identify your most important issues, deal with them as fast as you can. Of course, there would be in this kind of session, there's engagement between council and the court, and that may take a bit of your time, but ensure that your most important points are actually captured by the court. When you do that and you still have some extra time left, you can now deal with the other issues, but ensure that the court gets to know what your main point is. Usually, in this kind of an engagement where you are basically highlighting your case, you want to ensure that if the court forgets about everything that you said, there are certain salient points that the court should not miss. And that's what matters in this kind of engagement. Otherwise, thank you very much.
Yes, the art of advocacy is very important. You can have a lawyer who knows everything, but he cannot communicate. So communication is very important. Secondly, when you appear before a bench like this, you can be sure each member of the bench is looking for something different, unlike when it is a one-judge bench. For example, there's one very important aspect I've missed. Is Murima an island? It does not belong to any other international organization. You all concentrated on local legislation. What about the international law? Murima's obligation under international law. That's very important. Look beyond the national borders, because Murima is not an island. Thank you.
So, nothing else? Okay, thank you very much. We'll adjourn.